has been rendered unfair to the extent of being entirely vitiated because of the fact that the applicants have been prosecuted by a prosecutor who is prepared to and planned to suborn state witnesses to commit perjury in order to secure a conviction." End quote. Has there been an irregularity or irregularities in that the prosecutor acted contrary to what is expected of a diligent prosecutor? At the heart of this application for a declaration of a mistrial is the conduct of the lead prosecutor, Mr. Ntelwa, that came to light during the testimony of Ms. Gianni, the complainant in counts 14 and 15. The standard of conduct required of a prosecutor has been referred to in the interlocutory judgment in the application to have Ms. Serfontein called as a witness in terms of the provisions of Section 186 of the Criminal Procedure Act. I will not deal with that aspect in detail again. In Minister of Police and Another versus Duplessis, NAFSA ADP, with reference to other authorities, made the following remarks. I quote, "In Democratic Alliance versus President of the RSA and others, this court, after discussion concerning prosecutorial independence in democratic societies, quoted with approval the following part of a paper presented at an international seminar by Mr. James Hamilton, then substitute member of the Venice Commission and Director of Public Prosecutions in Ireland. Despite the variety of arrangements in prosecutors' offices, the public prosecutor plays a vital role in ensuring due process and the rule of law, as well as respect for the rights of all the parties involved in the criminal justice system. The prosecutor's duties are owed primarily to the public as a whole, but also to those individuals caught up in the system, whether as suspects or accused persons, witnesses or victims of crime. Public confidence in the prosecutor ultimately depends on confidence that the rule of law is obeyed. We should all be concerned about the maintenance and promotion of the rule of law. Given increasing litigation involving the NDPP, these principles cannot be repeated often enough. We ignore them at our peril. In State v. Van der Westhuizen, the following was said with regard to the function of a prosecutor. I quote, "In our practice, it is not the function of a prosecutor disinterestedly to place a hodgepodge of contradictory evidence before a court and then leave the court to make of it what it wills. On the contrary, it is the obligation of a prosecutor firmly but fairly and dispassionately to construct and present a case from what appears to be credible evidence and to challenge the evidence of the accused and other defense witnesses with a view to discrediting such evidence for the very purpose of obtaining a conviction." That is in essence the process of a prosecutor's function in an adversarial system and is not peculiar to South Africa. And at paragraph 13, I quote, "I would emphasize, however, that it is not necessarily sufficient for the prosecutor to tender state witnesses to the defense at the end of the state's case, nor does the prosecutor necessarily discharge the duty of disclosure by making available the contents of the dossier. If there is evidence which the prosecutor knows or ought reasonably to suspect is or may be destructive of the state case, or which tends or might tend to support the defense case, and which the prosecutor knows or ought reasonably to suspect is not known to the defense, it is the prosecutor's duty to bring this evidence specifically to the attention of the accused's legal representatives. It would therefore, for example, not be necessary for a prosecutor to draw attention to a specific witness's statement favorable to the accused in the dossier made available to the defense, for he who runs may read, but the prosecutor would be obliged to inform the defense that a particular witness who has not given a statement might to the defense's advantage be consulted, and why, and also to assist when necessary in making such a witness available. And the prosecutor would also be obliged to furnish the defense with a document which is not in the dossier, which favors the accused's case, or which is destructive of the state's case, which the prosecutor believes or ought reasonably to believe is not in the possession of the defense." End quote. It is necessary to give a history of the case even before the trial started de novo, after Makula J. recused himself. The indictment was served on the accused on 1 June 2019. A request for further particulars was filed, and the further particulars was supplied on 24 July 2019. On the same date, unbeknown to myself, the first indictment was removed and replaced with an amended indictment that I will refer to as the second indictment. It was brought to the attention of the court that the indictment before court, the second indictment, was not the same indictment that the accused faced before Makaula J, when the issue of jurisdiction of the court was argued, without disclosing that it was not the same indictment that was served on the accused on 1 June 2019. Mr. Ntelwa informed me at the time that there were only minor differences in the new indictment, inter alia the amendment of the charge of sexual assault to rape in respect of the counts relating to Ms. Gianni, and there were additional places where the incidents occurred in respect of some of the counts, without disclosing that it was not the indictment that had been served on the accused. As stated in the judgment relating to the application by the accused that I must call Ms. Serfontein as a witness in terms of the provisions of Section 186 of the Criminal Procedure Act, while Ms. Gianni testified, it came to light that she had made a contradictory statement to Ms. Serfontein, which had not been disclosed to the defense. Subsequent to my refusal to call Ms. Serfontein as a witness, emails that had been exchanged between Ms. Serfontein, Mr. Gounden, Mr. Ntelwa, and Ms. Goberdin, that I will refer to as the prosecutors collectively, were disclosed to Mr. Doberman. It was these emails that precipitated the present application. These emails made it clear that before the trial commenced before me, Ms. Serfontein had informed the other prosecutors that there had been discrepancies that came to the fore between the police statements of 4 witnesses and her consultations, and therefore between the indictment and the witness's statements. It is necessary to quote the email of Ms. Serfontein and Mr. Ntelwa's reply thereto verbatim. They read as follows. From Ms. Serfontein to the other prosecutors. Dear colleagues, I quote, "It is with great concern that this email is drafted. As you are aware, I'm currently busy consulting with the witnesses of Secunda Mpumalanga. I'm hoping to finalize my consultation with the complainants by the end of the day, with the exception of Patricia Motsuning. As per my previous email, Sarah Mafikeng, counts 35 to 37, said that he inserted his penis into her mouth as well, and count 37, as per our indictment, only refers to penile penetration. Yesterday, I consulted with Lerato Msibi, counts 54 to 55, and with Malusia Gianni, counts 4 and 15. According to count 15, sexual assault, which relates to Ms. Gianni, she said, as per our consultation yesterday, that the accused inserted his fingers into her vagina. This alters the charge to one of rape, digital penetration, and not sexual assault. According to count 55, sexual assault, which relates to Ms. Msibi, as per the consultation, the time frame should read 2012 to 2016, and sentence should be included in the charge, as the first sexual assault occurred in 2012 at the Sandton Hotel and stopped in KZN during 2016. I'm of the view that the indictment must be amended accordingly, in brackets, even though I am sure our learned friend will bring all sorts of applications, in brackets. The complainant's credibility could be negatively affected, and I would prefer us to avoid a situation, brackets, as you would too, in brackets, where complainants say, I quote, "But I informed the prosecution," end quote, and the indictment does not reflect their oral evidence. Kindly advise if you are in agreement. I will provide you with the feedback after I concluded my consultations with the witnesses as stated above. Regards. From Mr. Ntelwa to all his colleagues. Good morning. I suggest that the amendment should only be in respect of Msibi's period. As for Gianni and Sarah, I suggest that we leave those counts be, because it will impact so negatively to the case. The proposed changes have the effect of changing the charges completely and will cause the defense to request more time to consult, and in order to do that, they will need a fresh witness's statement to that effect. That will delay the start of the case. The said witnesses had a chance of disclosing this during their police statements, brackets, each has 3 statements, end brackets, and during our consultation with them. As they failed to mention this on 4 occasions, they must leave that portion in their evidence, end of the quote. Ms. Serfontein forwarded Mr. Ntelwa's reply mentioning, I quote, "must leave that portion in their evidence," with an exclamation mark, end quote, to Mr. Gobadon, who replied with, I quote, "Oh God," end quote. This clearly an indication that Ms. Gobadon found the attitude of Mr. Ntelwa unacceptable as expressed by Ms. Serfontein. Nothing came of Ms. Serfontein's feeling of disquiet. Mr. Gandon, the senior of Mr. Ntelwa, offered no comment and did not do anything regarding the proposition of Mr. Ntelwa. However, he discussed the matter with Ms. Serfontein, and the second indictment incorporated the amendments as suggested by Ms. Serfontein. This was done without obtaining further written affidavits from any of the witnesses, and according to Mr. Ntelwa, without discussing it with him. There are discrepancies between Ms. Serfontein's consultation notes and the main gist of her affidavit in opposition to the instant application. Her consultation notes, as well as her email to her colleagues, indicated that Ms. Gianni told her that the first applicant put his finger into Ms. Gianni's vagina, while Ms. Gianni testified that the first applicant's fingers were at the mouth of her vagina. In Ms. Serfontein's affidavit in opposition to the application, It is mainly stated that she made a mistake by stating that Ms. Gianni informed her that the first applicant put his finger into her vagina as he did not penetrate her vagina. However, in another paragraph she states under oath that Ms. Gianni told her that the first applicant put his finger into her vagina. This was made off during argument as a mistake, but such sloppy work is unacceptable in the light of the fact that this discrepancy is what precipitated this whole application. Mr. Ntelwa, a senior advocate with 14 years prosecutorial experience, stated under oath that he consulted with all the witnesses, made consultation notes but did not keep those notes. He did not realize that Ms. Gianni's statement that the first applicant put his fingers at her vaginal mouth and thus passed her labia majora had the result that the first applicant had raped her according to the definition of rape, sexual penetration and genital organs as set out in sections 3 and 1 of the Sexual Offences Act. The salient provisions of these sections determine as follows. Rape is defined in section 3 as follows. I quote, any person, A, who unlawfully and intentionally commits an act of sexual penetration with a complainant, B, without the consent of B, is guilty of rape. End quote. Sexual penetration includes any act which causes penetration to any extent whatsoever by B, any other part of the body of one person into or beyond the genital organs of another person. Genital organs include the whole or part of the female genital organs. It is unthinkable that a senior prosecutor with 14 years experience that is involved with a case that specifically deals with sexual assault and rape can be so remiss in his duties that he had not read the relevant definitions in the Sexual Offences Act. In his answering affidavit, Mr. Ntelwa, in answer to the allegations that he was proposing to suborn the state witnesses concerned to commit perjury, he merely, I quote, concedes that I did not express myself well, but I simply intended giving my input to Advocate Gandon and Advocate Serfontein to clearly consider whether the prosecution should attempt to amend the indictment so drastically at such a crucial time. End quote. Furthermore, quote, I do concede that the formulation of my proposal was unfortunately worded, end quote. Despite mentioning that his proposal was unfortunately worded, he did not explain what he meant by those words. His explanation creates the impression of an attempt at fancy footwork. I'm of the view that the only possible interpretation is that he wanted the witnesses not to deviate from their police statements. This would have had to entail encouraging the witnesses not to give another version to court, which could have the result that the witnesses were encouraged to commit perjury. Ms. Serfontein clearly had the same misgivings when she read the email of Mr. Ntelwa. Despite reporting that to his superiors, no action was taken either by Ms. Goberdin or Mr. Gandon to determine what Mr. Ntelwa had meant by his email and to correct him if necessary. Clearly, Ms. Goberdin had the same misgivings as Ms. Serfontein, for when she was alerted to the relevant portion of his email, she only replied with, "Oh God." This is confirmed in Ms. Goberdin's affidavit, where she stated that she was disturbed by Mr. Ntelwa's view, which could be interpreted that he intended to lead Ms. Gianni on a version contrary to what she had informed Ms. Serfontein. The state was clearly remiss in dealing with the contradictions in the witnesses' statements. Affidavits had to be obtained from the witnesses and an application had to be brought prior to the accused pleading to the charges for amendments. Due to the state's failure to do so, there had been an unnecessary opposed application during the trial for amendments, which were only partly successful. The fact that there had been contradictions in the witness's statement should have been disclosed to the defense. This was the position even before the constitutional era. Prior to the emails being disclosed to Mr. Doberman and shown to court, there were attempts by Mr. Ntelwa to keep his knowledge about the discrepancies in the evidence from me when I directly asked him about his knowledge about the two contradictory statements. It is clear from the above stated required conduct that Mr. Ntelwa did not act in accordance with the requirements of a prosecutor. Neither did his superiors in their overseers' roles instruct him to act according to his duties as a prosecutor. Mr. Ntelwa's conduct in failing to apprise Mr. Doberman of the contradictory statements constituted an irregularity in the context of this case. Furthermore, the actions of Mr. Ntelwa cannot in any way be condoned. Did the irregularity result in a failure of justice? And if so, should I order a mistrial? Kentridge AJ said the following in State v. Zuma and others when referring to the interim constitution and the right to a fair trial. The right to a fair trial confirmed by Section 25(3) is broader than the list of specific rights set out in paragraphs A to J of the subsection. It embraces a concept of substantive fairness, which is not to be equated with what might have passed muster in our criminal courts before the Constitution came into force. In State v. Rudman and another, State v. Mtwana, the appellate division, while not decrying the importance of fairness in criminal proceedings, held that the function of a court of criminal appeal in South Africa was to inquire whether there has been an irregularity or illegality, that is, a departure from the formalities, rules and principles of procedure according to which our law requires a criminal trial to be initiated or conducted. A court of appeal, it was said, I quote, does not inquire whether the trial was fair in accordance with notions of basic fairness and justice, or with the ideas underlying the concept of justice, which are the basis of all civilized systems of criminal administration. And that was an authoritative statement of the law before 27 April 1994. Since that date, Section 25(3) has required criminal trials to be conducted in accordance with just those notions of basic fairness and justice. It is now for all courts hearing criminal trials or criminal appeals to give content to those notions. In Sanderson versus Attorney General of the Eastern Cape, Kriegler J. emphasized the necessity to conduct criminal trials in accordance with basic fairness and justice, and stated that a narrow textual approach as to the position prior to the constitutional dispensation might miss important features of the fair trial provision. He stated, the central reason for my view goes to the nature of the criminal justice system itself. In principle, the system aims to punish only those persons whose guilt has been established in a fair trial. Prior to finding on liability and as part of the fair procedure itself, the accused is presumed innocent. He or she is also tried publicly so that the trial can be seen to satisfy the substantive requirements of a fair trial. End quote. In State v. Zukiswa and others, State v. Chilu, Ackerman AJ referred to the concept of substantive fairness and said, elements of this comprehensive right are specified in paragraphs A to O of subsection 3. The words, which include the right preceding the listing, indicate that such specification is not exhaustive of what the right to a fair trial comprises. It also does not warrant the conclusion that the right to a fair trial consists merely of a number of discrete sub-rights, some of which have been specified in the subsections and others not. The right to a fair trial is a comprehensive and integrated right, the content of which will be established on a case-by-case basis as our constitutional jurisprudence on Section 35(3) develops. It is preferable, in my view, in order to give proper recognition to the comprehensive and integrated nature of the right to a fair trial, to refer to specific and unspecified elements of the right to a fair trial, the specified elements being those detailed in subsection 3. And he continued, at the heart of the right to a fair criminal trial and what infuses its purpose is for justice to be done and also to be seen to be done. But the concept of justice itself is a broad and protean concept. In considering what, for purposes of this case, lies at the heart of a fair trial in the field of criminal justice, one should bear in mind that dignity, freedom, and equality are the foundational values of our Constitution. An important aim of the right to a fair criminal trial is to ensure adequately that innocent people are not wrongly convicted because of the adverse effects which a wrong conviction has on the liberty and dignity and possibly other interests of the accused. It is the applicant's contention that the right to a fair trial had been infringed to such an extent that there are no prospects of justice being done, and the only proper order for me to make would be to declare a mistrial. Irregularities committed during a trial are dealt with in the Criminal Procedure Act in sections 317, a special entry, section 318, which determines that if a special entry is made on record, then the accused may appeal his conviction, and section 322, which determines that on appeal it may allow the appeal if the judgment should be set aside on account of the irregularity. Thus, although there are irregularities committed during a trial and irregularities that come to the fore after conclusion of the trial, a special entry can be applied for during the trial or after conclusion of the trial, but special entries are dealt with at the appeal stage. It is not every irregularity that would have a conviction set aside, but only if an injustice had occurred. This had been the position even before the advent of the constitutional era. It was confirmed in State v. Delport that an irregularity does not in itself lead to a failure of justice. In Jaipal v. the State, the Constitutional Court stated that, I quote, the right of an accused to a fair trial requires fairness to the accused as well as fairness to the public as represented by the state. It has to instill confidence in the criminal justice system with the public, including those close to the accused as well as those distressed by the audacity and horror of crime. As was determined in Porritt v. the NDPP, where a prosecutor's bias affects the accused's right to a fair trial, he/she might well be disqualified. Chiki referred with approval to the Zimbabwean case of Smythe v. Ushiwokunze and another, where the facts were that Mr. Smythe, who ran several youth camps, was charged with culpable homicide after a boy had drowned, as well as 5 counts of criminal injuria relating to his molestation of some of the boys at the camp. The prosecutor was a brother of a boy who attended 2 of the camps and a potential state witness. He conducted the prosecution in a manner that was, I quote, overzealous, vindictive, and at times patently dishonest in that he deliberately misled the court, end quote. He was discharged from the case, and the court held that Mr. Smythe had shown that his right to a fair trial is in jeopardy if the first respondent proceeds as the prosecutor in the matter. If an irregularity occurred during the trial when cross-examination was irregularly curtailed, the necessity of making a special entry can be avoided by recalling the witness for further cross-examination. In National Director of Public Prosecutions v. King, it was also confirmed that potential prejudice might be rectified, and I quote, rights broader than those rights specifically conferred by the fair trial guarantee therein, and embraces a concept of substantive fairness that is not to be equated with what might have passed muster in the past. This does not mean that all existing principles of law have to be jettisoned, nor does it mean that one can attach to the concept of fair trial any meaning whatever one wishes it to mean. The question remains whether the right asserted is a right that is reasonably required for a fair trial. A generous approach is called for. This is a question for the trial judge, and there is in general not an a priori answer to the question whether a trial will be fair or not. Potential prejudice may be rectified during the course of the trial, and the court may make preliminary rulings depending on how the case unfolds, and may revoke or amend them. Irregularities do not lead necessarily to a failure of justice. It is clear from this that an irregularity or the result of an irregular procedure can be ameliorated during the trial depending on the specific circumstances in the trial and the irregularity concerned. The irregularity in the present instance came to light while the witness, whose testimony is under suspicion of having been suborned, was being cross-examined, and whose cross-examination has not been concluded. The importance of cross-examination cannot be overemphasized. In Carroll v. Carroll, Hennigsberg A.J. said, quote, "The objects sought to be achieved by cross-examination are to impeach the accuracy, credibility, and general value of the evidence given in chief, to sift the facts already stated by the witness, to detect and expose discrepancies, or to elicit suppressed facts which will support the case of the cross-examining party." The differences highlighted by Ms. Serfontein in respect of the witnesses she had consulted with came to light through 1. The filing of the second and irregular indictment, where in respect of count 15 the charge was changed to rape instead of sexual assault. 2. A psychologist's report that was part of the docket that had been discovered to Mr. Doberman prior to the commencement of the trial, which stated that Ms. Gianni reported to the psychologist that she had been raped. And 3. The emails exchanged between the members of the DPP. Points 1 and 2 allowed Mr. Doberman to cross-examine the witness with regard to the discrepancies that came to light and to elicit the previously suppressed facts. Point 3 only came to light after the emails were disclosed to Mr. Doberman and while the cross-examination of Ms. Gianni had not been concluded. The discrepancies were not something that came to the fore only after the close of the case or before the finalization of all the evidence. Ms. Gianni has been cross-examined on the discrepancies and she can further be cross-examined. Unfortunately, in every case, there is the possibility that the witness may lie or be influenced to lie or lie during duress, and sometimes we will never know why they lie. This is the reason why cross-examination is such an important tool in an adversarial system as ours. In terms of Section 173 of the Constitution, the High Courts have the inherent power to protect and regulate their own process and to develop the common law, taking into consideration the interests of justice. Although an application to have a mistrial declared in the middle of a trial is a foreign concept, and I was not referred to any other South African case where such a declaratory order had been made, such an order might form part of an inherent power to regulate the process of court. Whether an accused will receive a fair trial is a question to be answered most appropriately against the background of all the evidence and at the end of the trial. A trial court must be satisfied at the end of a trial that an accused has received a constitutionally fair trial, and if not, then the accused must be acquitted. In Sanderson, the Constitutional Court said, with reference to an accused's right to a speedy trial, that the state is also entitled to that right, and the public interest is served by bringing litigation to finality. In State v. Zuma and another, Kun J said the following, and I quote, "Ultimately, the inquiry at the end of every criminal trial must be whether the accused had received a constitutionally fair trial. The inquiry is one most best answered by the trial court at the end of the trial, when the materiality of all the evidence adduced can be assessed properly. That is not to say that such an inquiry might never, possibly in exceptional circumstances perhaps, arise, if appropriate, during a trial. But when such a determination, other than at the end of the trial, should be made, is solely within the discretion of the trial judge." As previously stated, it is important that it is not only the accused that is entitled to a fair trial, but also the victims of crime and society as a whole. In this criminal case, most of the complainants have not testified, and it would impact on their rights if they did not have their day in court, and would be detrimental to the administration of the justice. The cross-examination of these witnesses will enable Mr. Doberman to establish whether there was any attempt to influence them to testify in a certain manner. With regard to the conduct of Mr. Ntelwa, I am satisfied that it would not be appropriate that he should continue with the prosecution of the case. I would find it difficult to rely on his assurances in this matter. He might have encouraged witnesses not to deviate from their police statements, even if the statements might not have been taken down with the necessary care and therefore not reflect the true state of affairs. Although there has been no application by the defense for Mr. Ntelwa to be replaced, in spite of the fact that it became obvious prior to the judgment on Section 86 of the Criminal Procedure Act that he did not properly fulfill his duties, I am of the view that it would not be in the interest of justice and the accused's right to a fair trial that he remains a prosecutor in this case. Conclusion. This application was brought on the basis that Mr. Ntelwa suborned witnesses or attempted to do so. It is not common cause that Mr. Ntelwa tried to suborn witnesses. As previously stated, in application proceedings, there is no onus and it is decided on common cause facts. Here there are no common cause facts which show that the witnesses have been suborned or that there was an attempt to do so. Although Mr. Ntelwa's explanation for his email is unsatisfactory, it cannot be found that he indeed suborned witnesses or attempted to do so. Such a finding would be based on speculation and not on the evidence presented in the trial, which can only be assessed after all the evidence has been led. But, as previously stated, he had committed an irregularity and I cannot rely on his assurances in this matter. I am of the view that the irregularity is not of such a nature that I can find at this juncture that it resulted in a failure of justice and it rendered the trial unfair to such an extent that the accused could not have a fair trial as expressed in Section 35(3) of the Constitution. Mr. Doberman had the opportunity to cross-examine the witness and can further cross-examine her after the trial recommences. He can also apply to recall other witnesses if he so wishes. Under those circumstances, the irregularity did not lead to an injustice that must be decided at this stage. The door remains open, if all the evidence is considered, to find that the accused did not have a fair trial. But it is not an issue that should be decided at this stage. It may, in exceptional circumstances, be appropriate to make such an order during the trial. However, that is not the position in the instant matter. The application for the declaration of a mistrial is dismissed, and the alternative remedy proposed that I should recuse myself is also dismissed. The court will adjourn.
All right.